Hello everyone, this is Korean Law A to Z. I'm your attorney, Jiwon Lee. In the previous episode, I introduced how to proceed with a criminal lawsuit in Korea. Today, I would like to apply it to real-life situations, mainly about the violence and fraud, which are the most common crimes. Here is what the Korean Criminal Act defines about the crime of violence. Criminal Act Article 260 states, "A person who uses violence against another shall be punished by imprisonment for not more than 2 years, a fine not exceeding 5 million won, detention, or a minor fine." For example, suppose you started a quarrel with your colleague and it became physical. Or suppose you visited the bar and a random drunk person picked a fight with you for no reason. Once you get involved in a physical fight or life-threatening situation and need emergency help, please always call 112. However, there might be a situation where your opponent or a bystander calls the police beforehand. So a policeman could approach the scene before you get to call them first. In this case, it's possible that the policeman might mistake you as the injurer. If this actually happens, first, don't panic, and second, state your own explanation to the police officer at the scene, either in English or in Korean. You have to make sure the police officer understood your situation because the police report which describes the scene will be the key evidence of the case, and the police officer who was present at the scene will be the key witness. You can check the police report via the internet by submitting a request of information disclosure or visiting the public service center at the nearest police station. If both parties insist that I'm the victim, the policeman has no choice but to charge both parties with a crime of violence. Once you're charged, you have to attend the police station and go through the questioning by the police. So if the police subpoena you, then get your attorney before you get into the criminal lawsuit. Here's one interesting fact. Korean Criminal Act Article 260 Clause 3 states that the crime of violence shall not be prosecuted over the express objection of the victim. Therefore, if both parties agree to close the case and decide not to pursue any more compensation against each other, then the case will be closed immediately. However, this doesn't apply to the case which involves bodily injury. A person who inflicts bodily injury upon another shall be punished. Once a medical record is submitted to the police by either one of the parties, which states a minor bruise, bleeding, contusion, then the case is no longer considered as a crime of violence, but a case of bodily injury. In this case, the law enforcement agency must indict someone who inflicted such injury, even if both parties agree to close the case. Now, let's take a look at the case of fraud. Criminal Act Article 347 states, "A person who defrauds another, thereby taking property or obtaining pecuniary advantage from another, shall be punished by imprisonment for not more than 10 years or by a fine not exceeding 20 million won." Fraud can be committed in various ways. But there are two key components which are required in order to form an act of fraud. One, deceitful act against the victim, and two, obtaining an economic benefit by that deceitful act. So if your landlord rents you an uninhabitable house and defrauds your deposit or monthly rent, or if your contractors refuse to give your salary back, then their act is considered a crime of fraud. In this type of crime, a crime against someone's property requires a piece of visible evidence and a legal argument built on sound logic. Therefore, filing a written complaint is better than just reporting the case to the police by 112. If you have any question regarding a specific case, please contact down below and I will be available to help you. Again, this is your attorney, Jiwon Lee. Thanks for watching.